so much. The next person on the list is Mr. Cooper.
Thank you, Mr. Chair. I have a few comments, but I do have a question picking up on the point that Mr. Paul-Hus raised, which is in respect of the motion that has been put forward by Mr. Boissonnault. We have three individuals on the list. Of course, a number of the key actors coincidentally excluded. I was wondering who called these witnesses in advance. Was it you, Mr. Boissonnault? Was it you, Mr. Chair? Who called them?
Who called them? My understanding was that Mr. Boissonnault. Do you have that answer?
Well, I do have an answer.
My
colleagues in government reached out to these people, and they indicated that they will be able to.
Is that PMO?
No,
it is not PMO.
No.
Have they called Mr. Butts?
Again, we have not, and we purposely, just to be clear.
Did Mr. Butts refuse?
We have purposely, the members of this committee, because, indeed, of the enormous allegations that were coming that you guys were putting out that PMO would somehow kibosh this, would tell Liberals in the committee how to act. We deliberately, very, very deliberately have not in any way contacted anybody in PMO, which is why you would never see Mr. Butts' name there. We have not done that. It's funny. You guys on social media have gone all over saying the Liberals on the committee are going to kill this.
Mr. Chair, I asked a very straightforward question, which was who called these three witnesses. There was no clear answer provided. I asked of the other individuals on the list of our motion, were they contacted too? I haven't received an answer to that, and I simply ask it again. It's a straightforward question.
So my understanding is nobody else has yet been contacted.
Just those three individuals.
Yeah,
very interesting. Very interesting that the key actors, Mr. Butts, Ms. Telford, and others were not contacted yet. It says a little bit about maybe where the Liberal members on this committee want to go. And I've got to say, in response to Mr. Boissonnault, before I came here today, I was really hopeful, given the work that we've done as a committee together, that Liberal members on this committee would be as concerned as I and my Conservative colleagues are, as well as New Democrats, Mr. Rankin, I think most Canadians, about the very serious allegations which, if proven true, speak to corruption at the highest levels of the PMO. I was hopeful in light of that Liberal members on the committee would want to put the public interests ahead of the interests of the PMO and the interests of the Liberal Party. And what we see today, in fact, is just the opposite. And Mr. Boissonnault, in his comments, spoke about the need to dig in and hear about the remediation agreements and deferred prosecution agreements. Well, you know what? I have to say it's quite ironic, because I wish our Justice Committee had the time to examine deferred prosecution agreements. I wished that had come to our committee, where we could have heard from witnesses, where we could have looked at the merits of deferred prosecution agreements. But guess what? That didn't happen. Why didn't it happen? Because the finance minister, through the budget omnibus bill, decided to sneak it in. So there was no debate. There was no consultation. There was no consideration. And now we know it was because SNC-Lavalin was busy begging and pleading and lobbying officials in the PMO. So the fact that Mr. Boissonnault wants to go on at length studying these remediation agreements, I think speaks to the fact that Liberal members aren't interested in getting answers. They're not interested in getting to the bottom of this, because guess what? The policy around deferred prosecution agreements have nothing to do with the issue at hand. The issue at hand relates to whether officials in the PMO put pressure on the Attorney General, the former Attorney General, Ms. Wilson-Raybould, to interfere in an independent prosecution, a criminal prosecution of SNC-Lavalin. That is what the issue is. And let me cite need there be any clarity, the Krieger decision of the Supreme Court that says, quote, "It is a constitutional principle that the attorneys general of this country must act independently of partisan concerns when exercising their delegated sovereign authority to initiate, continue, or terminate prosecutions." Let me also cite the Supreme Court in the Heinz decision, where the court says at paragraph 40, quote, "The decision to initiate or continue criminal proceedings lies at the core of the Crown prosecutor's powers, and the principle of independence of the prosecutor's office shields prosecutors from the influence of improper political factors. Prosecutors must be able to act independently of any political pressure from the government and must be beyond the reach of judicial review. This independence is so fundamental to the integrity and efficiency of the criminal justice system that it is constitutionally entrenched." That is the issue before us, not the policy issue about deferred prosecution agreements that the government didn't bring before Parliament in a transparent way and snuck it through. Mr. Boissonneau talked about solicitor-client privilege. Well, we've said it before and I'll say it again. The Prime Minister can simply lift the solicitor-client privilege. He has the power to unleash Ms. Wilson-Raybould so that she can come forward and speak the truth. But he doesn't want to do it because, you know why? Because I think when she does, and if she does, he's not going to like what she says. And to the point that was made about, well, we've always had these discussions in camera about witnesses. We've normally had these discussions in camera. Well, guess what? This is not a normal matter. This is about corruption at the highest levels of the PMO, and if Liberal members on this committee want to whitewash it, want to cover it up, want to shut down the opposition and our ability to bring these individuals forward to committee so that we can ask the questions and try to get the answers that Canadians deserve, you're going to have to do it in public. And you can be answerable to your constituents, and you can be answerable to Canadians. And with respect to the point about having a meeting to discuss witnesses, I see the Liberal motion. It has 3 witnesses on the list. We can talk about witnesses. We don't need to wait until another meeting. Why don't we just discuss the witness list today? Let's get on with it. Let's get on with it now. Canadians deserve us to get on with it so that we can bring these individuals before us at the earliest possible opportunity, something that this motion doesn't provide, something that our Conservative motion does provide.
Thank you very much. Mr. Fraser.
Thank you, Mr. Chair. So I think there's a few things here that are extremely important to highlight. First of all, as the chair mentioned, the way that witnesses are generally agreed upon by the various members of a committee, timetable for studies, those are all done in camera. We also have the added element of the sub judice rule, which may, as the motion alludes to, require us to obtain possibly a legal opinion. There are real issues at play here with regard to a matter that is currently before the court dealing with SNC-Lavalin that we have to be very sure that we are not improperly encroaching on an area that is properly under litigation in the courts. We have to make sure that we are doing the right thing. I hear about independence of the judiciary from my friends opposite, but this strikes to the heart of that. If we're going to be encroaching on a matter that is currently before the court, that is the subject of litigation, we have to be really sure that we're not doing something improper as a committee. And so that discussion, in the terms of this motion, will happen in camera, and that's perfectly normal. That's the way this usually would go. I agree with Mr. Cooper. This is certainly an unusual circumstance. Obviously, having this matter come before our committee in this fashion is an unusual tool to use. We are trying to find a way as committee members to work with them on finding an avenue forward. I believe the motion is clear that we're going to deal with it relatively quickly in camera on Tuesday, February 19th, as the motion says. It's the perfectly normal way that those discussions would happen amongst committee members. I want to also make clear that the purpose of this motion is that future meetings would be in public. We're talking about an in-camera meeting to discuss those issues that are normally dealt with in camera, with the added element of a legal principle of sub judice rule that we have to consider as a committee to ensure that we are not doing something improper. I want to turn to Mr. Paul-Hus's statement. He talked about lobbying with SNC-Lavalin. I mean, we know that there are oftentimes discussions with politicians and lobbyists. That's normal. We know that Andrew Scheer met with SNC-Lavalin. We know that other politicians met with them to discuss a remediation agreement. We know, as Mr. Boissonneau said, that remediation agreements, or deferred prosecution agreements, as the members opposite have been calling it, are perfectly usual in other countries that we deal with on a regular basis. I think it is important to put in context of the whole context of this situation, the purpose of remediation agreements, which is why my understanding is that it's in this motion. I don't think it's just an aside that we should ensure Canadians understand what the Shawcross Doctrine is and be able to understand what remediation agreements are. But we have to make sure that we're doing it in a thoughtful way. I would note as well that Mr. Poilievre sits on the Finance Committee that would have dealt with the issue of remediation agreements. And I don't recall a discussion at that time that the matter should come to our committee from Mr. Poilievre. I think there's a number of issues at play here that we do need to take seriously. I think the members on this side of the committee are willing to take these matters seriously and work with our friends in the opposition. But going back to the original preface, I guess, of the chair's comments, if there is truly an interest to determine these items, then we need to do so in a way that will have the confidence of Canadians. What I've seen here today, I'm not sure would carry the confidence of Canadians. I will leave my comments at that and say that I will be supporting this motion unamended.
Thank you very much. We will now come back to Mr. Cullen, who had the floor for proposing an amendment.
We're to the amendment now?
Yes.
How exciting.
Monsieur Fordin, vous êtes sur la liste?
Oui.
Mais vous êtes...
You are on the list, but there are several others on the list. I told Mr. Cullen that once we got to the end of the list, I apologize, I didn't understand. Mr. Cullen, go ahead.
My friends, of course committees have the power to investigate. We're doing that right now on Cambridge Analytica and Facebook at the Ethics and Access to Information Committee. Of course we have the power. The question is whether we want to use the power or not. This committee can subpoena witnesses. This committee can deliver findings to the House of Commons and in the full public light of day. The Ethics Commissioner will do very good work, and you'll only see the report. You won't see the interviews, you won't see the questions, you won't see the cross-examination. It bears some suspicion, my Liberal friends, that the only people you put on your witness list are people, 2 out of 3 have already publicly said they don't think there's anything to see here. That's somehow a coincidence, that the witnesses, Randy, you've offered up witnesses already. We're talking witnesses, so we're going to talk about them today. The people that have been alleged to be involved in what is one of the most serious cases that I've seen in my life in politics are not on your list. The people that are on your list that have publicly said, we feel that everything was done properly. In terms of, my friend, the independence of the judiciary, that note should have been passed around the Prime Minister's office some months ago. that if we do respect that, then these allegations that we're now seeing printed in our national newspaper wouldn't have come to light because they wouldn't have happened. That we have very clear rules delineating the ability to try to influence the independence of the Attorney General, to then influence the Prosecution Council. It seems disturbing to me, and to the point around this amendment that SNC-Lavalin lobbied your government exhaustively for, and they spent a lot of money doing it, as they did spending $500,000 in donations to your party, and another 100,000 of which were illegally donated to your party from SNC-Lavalin. Here's what your Liberal member on the committee said about this amendment. What strikes me as being wrong is that these remediation provisions seem to be focused on white-collar crime, or at least limited to white-collar crime. It leaves a bad taste in my mouth, in the sense that it seems we're going to let off people who commit a very serious economic crime, which has very serious effects against those who are not capable of negotiating these agreements in other crimes they might be victims of or perpetrators of. We seem to be letting off people in white-collar crimes with a little slap on the wrist. And here's what the Liberal chair of the Finance Committee said. There is a huge question of whether this should be in the budget bill. Even I will say that. It was slipped into the omnibus budget bill. It was not a financial measure. Who are we kidding? It was lobbied for by a multinational company. They secured that. The allegation is now, did they then lobby the Prime Minister's office to then put pressure on the former Attorney General, Jody Wilson-Raybould, to give them a plea deal so that SNC-Lavalin could keep bidding on lucrative federal government contracts? That's what this is about. They've been banned from World Bank contracts, and if they were found guilty in court of fraud and corruption, bribery, they would be excluded from bidding on lucrative federal government contracts. That's what this is about. Two sets of rules, as your Liberal members on committee at the Finance Committee said, gave them great concern. Special rules for those who are well-connected, and other rules for those that don't. Average Canadians, those in the middle class and working hard to join it, I think is the popular phrase. The power of this committee to actually find out what happened here is substantial. We are given this role on behalf of Canadians. To simply say this is a sophisticated legal book club, that we can explore and study and contemplate these things, would be to forego our responsibilities when we see something like this here. The witnesses you've offered are suspect in the sense that they've already made themselves known in their opinions on this. The other principal actors, and I'm going to say this now and I'll say it again, we should perhaps stop trying to speak for Jody Wilson-Raybould. We can invite her. We can offer her the opportunity, and she can use her counsel and her very good knowledge of law to decide what it is she will and will not say. The fact that Liberal committee members don't even want to hear from her is telling. If you do want to hear from her, Mr. Fraser, put her on the list. You phoned some other people. You had somebody phone some other people. You didn't phone Jerry Butts. Well, why not? It bears asking. And so to this, what I will suggest is this, that the Justice and Human Rights Committee hold meetings to examine the role of the Attorney General in Canada's system of justice and other pertinent legal matters, and that witness lists include, but not be limited to, the three that have been mentioned already, and including the former Minister of Veterans Affairs, Jody Wilson-Raybould, including Principal Secretary to the Prime Minister, Gerald Butts, including Senior Advisor to the Prime Minister, Matthew Bouchard, and that this committee meet on Tuesday, February 19th, 2019, at a time set by the chair, etc., as per the original motion. If my Liberal colleagues think that hearing from Jody Wilson-Raybould isn't of interest to Canadians, if my Liberal colleagues think that not hearing from the Principal Secretary to the Prime Minister who's implicated in this affair is not of interest to Canadians, and that his senior advisor, Mr. Bouchard, is not of interest to Canadians, I'll let you try to explain that. You can't circle around this whole problem and then suddenly say, we're just not interested in hearing from the principal actors. That makes no sense. And please don't say other witnesses as we may be considered. We're talking about witnesses today, Randy. Let's do it. And if you don't want to do that, if you don't want to have those people invited, we're about to have a vote and you can describe that. But to say, oh, we'll meet in camera and we'll discuss it in private, this is as obvious as the nose on my face. This is something that we got to do. And the nose on my face is pretty obvious. So I think we should get on with it.
So just so that I'm clear, your amendment, Mr. Cullen, is to add 3 additional people to the existing motion. Is that correct?
I've also suggested rewording in the very first sentence, and I can read it again more slowly if you...
Okay, yes.
That the Justice and Human Rights Committee hold meetings to examine the role of the Attorney General in Canada's system of justice and other pertinent legal matters. The attempt there is to allow for Shawcross, sub judice, those ones that we've all agreed are important. Comma, and that the witnesses list include, but not be limited to, the 3 that are mentioned in the original motion, plus the 3 that I just added. And the final addition is that the committee meet, and I strike in camera from the motion on Tuesday, February 19th, so that we can have an open conversation. I know it's a little unprecedented for this committee. This whole thing is unprecedented. The light of day is our best ally in all of this.
We'll try to get everything.
Yeah. Yeah. Okay. So as I understand it, there's 3 parts to the amendment, basically, but it's all one amendment that you're
Correct.
proposing. You would add 3 additional. Take the first paragraph and revise it to the wording that you proposed, and we'll all get a copy of it. And to remove the words "in camera" from the second paragraph.
From the very last. That's it.
Yeah. Okay. I hopefully will be able to get a copy shortly. So now, I guess we're now on the subject of the amendment. So I have a speakers list on the main motion. Do we now create a new speakers list in the amendment? Or will everybody who wants to speak on the main motion turn to the amendment now? So we have Ms. Raitt.
Thank you very much. Thank you very much, Mr. Chair. I will speak to the motion, and I will let the member know that we'll be voting in favor of it. We do think that that is getting to the point for 2 reasons. Number one, it does deal with the issue of the witnesses that do need to be heard in the situation. And number 2, we will reject any motion that has the proviso that this committee will meet in camera. That will be the clear line for the Conservative side of this committee. The reason being is that it is imperative that we have light shone on this and that we ensure that Canadians get to see what's going on specifically as the witnesses come forward. Mr. Chair, you said yourself that if there was a problem, the Attorney General would resign. You said that many times in the media, and indeed, she has resigned. So therefore, there is a situation here that does need to be studied, and that's why including her on the list of witnesses, as Mr. Cullen has done, makes sense and is actually imperative to our success in getting to the bottom of what happened. Secondly, Mr. Chair, sorry, I'm intrigued by what seems to be a difference of opinion on the purpose of the meeting. Now, I understand that the Liberal side is going to be voting in favor of their motion as unamended, as Mr. Fraser has said. I'll wait to hear what they have to say about the amendment that's Mr. Cullen now. But from the way in which it's been characterized on the Liberal side, they have indicated that Canadians want clarification on the relationship between the Attorney General and the Cabinet, whereas our point of view, and the point of view of most of the editorials in the Canadian newspaper world, is that we want to get to the bottom of political interference in the Attorney General's office. And just a quote from the decision that my colleague Mr. Cooper brought along from Alberta, the part of this decision that caught my attention is the following. The quasi-judicial function of the Attorney General cannot be subjected to interference from parties who are not as competent to consider the various factors involved in making a decision to prosecute. To subject such decisions to political interference or to judicial supervision could erode the integrity of our system of prosecution. I think that's exactly why we want to hear from the witnesses, Mr. Chair, because we want to determine what were the conversations that happened with the Attorney General and whether or not, according to the Supreme Court of Canada, this was something that is of concern. Finally, Mr. Speaker, my colleague... I'm so sorry about that, Mr. Chair.
It's okay.
Finally, Mr. Chair. Aspirations are always good. That's good.
I don't know if I can
Mr.
match
Chair.
our speaker, but thank you.
Mr. Chair, as my colleague, Mr. Cooper, has pointed out, and we have not received a response to this, and I think we deserve a response to this, both in the original motion, which has now been amended, but as well in statements made by members on the other side. There's a reference to this unknown group of government colleagues, our government colleagues. And my understanding is that our government colleagues had conversations with the Office of the Attorney General and discussions, so we want to understand what that is, and maybe there's going to be witnesses coming from our government colleagues. But as well, when you were pressed on who contacted the 3 witnesses, because you told us that they've agreed to show up already, that's why it's okay to talk about them as witnesses, we didn't really receive an answer as to who our government colleagues are in that case. I believe that we deserve an answer to who our government colleagues are that contacted these 3, and I will gladly sit here and wait until you give them to me.
So the next one, the next person on the list is Mr.
Point of order,
Sass.
Mr. Chair.
Yep.
I've asked a question. I'm wondering if you can illuminate for us as the chair, because you're in charge of the agenda, who are the government colleagues that called these 3 proposed witnesses?
Yeah, and so number 1, the word government colleagues I don't think was previously used. I'll turn to Mr. Boissonneau again to answer that question. But on the issue of the word government colleagues in the motion, the word government colleagues essentially comes from the doctrine itself and and discussions with people in cabinet in the Prime Minister's office and the Attorney General. It's in all of the literature related to the doctrine. That is words that are used with respect to where pressure may be applied and what is permitted and not permitted with respect to discussions between the Attorney General and prosecutors. So the words in the motion are not the words Mr. Boissonneau previously used.
Who are the government colleagues that called the 3 witnesses to determine that they were available?
Again, I will again ask Mr. Boissonneau, since I think it was his office that dealt with that.
So what we're talking about here is people who normally appear before this committee, and colleagues in working in the House Leader's office have been able to work with these 3 witnesses proposed, and there is openness to be able to appear before our committee.
Who in the House Leader's office made the calls to the 3 witnesses who are available to attend?
Are you trying to imply that there's something incorrect with the House Leader's office? Your House Leader's office is working with you right here. So somebody in the House Leader's office called the witnesses. I don't know if Mr. Boissonneau knows the exact name of the person. I don't believe he does.
Mr. Chair,
I've answered the question.
It took me and Mr. Cooper asking the question about 11 times before we got the answer. So forgive me if we are trying to plumb down as to
I don't think at all we're trying to play down, because there's nothing to hide in that. I think it's perfectly appropriate for the House Leader's office to reach out on the committee's behalf. We work with the House Leader's office all the time. What we've avoided doing, given all of the comments from the Conservatives over the last few days about how our committee would not support any motion, you're changing the narrative now. Before, we were not going to support anything. We were not going to do it. We were not going to shed light on this. Now we are. And you were saying because the PMO would drive us down. We deliberately didn't contact PMO because you guys were saying that we were going to be driven down by them. And I really do want to assert the independence of the members of this committee. I'm very proud of that. And I'm very proud of my colleagues and on all sides, to be honest, in the committee deliberations for the last 3.5 years. I'm so sorry. We're still on the amendment. Ms. Reid has spoken. We now have Mr. Assassi. Then so that everybody knows so you can get ready. We have Mr. Assassi, Mr. Boissonneau, Mr. McKinnon, Mr. Paul-Hus, Mr. Poilievre, Mr. Fortin, and Ms. Kellett. That is the speakers list, and perhaps at that point we might want to consider the amendment with Mr. Cullen having a last word on it, if that's okay with colleagues, and then move back to whatever happens after the amendment, whether other amendments or the main motion or whatever happens, because I think that's a lot of speakers on the amendment, if that's okay with everybody. So not hearing any objection to that for the moment, we're going to go to Mr.